Hello, my name is 220iKamaraCyber, and I'm here to present on cybersecurity laws. So we have the abstract. Most individuals now use the internet every day as part of their routine. Businesses utilize the internet in addition to individuals who use it for activities like banking, shopping, and bill payment. People's personal information is easily accessible on the internet since people bank, buy, and do business online. Since most people rely on technology, privacy and financial security must be protected by regulations. We have the overview. This examination of the literature will examine how internet safety, privacy legislation, and enforcement have changed over time based on a George Washington signed statute that dates back to 227 years. Although the All Rights of Acts of 1789 was enacted in the 1700s before the invention of the internet, federal courts have been reinterpreting this statute ever since in order to stay up to date with technological advancement. So we have contemporary use. So the solution could be found in a 2016 lawsuit between the US government and tech behemoth Apple. In this case, the FBI has requested that Apple give its employees personal iPhones which are accused of killing 16 people a backdoor for cryptographic killer. Apple has declined the FBI's request, stating that privacy protection is a priority. The All Rights Act of 1789 was utilized by federal judges to compare adherence to the code. Apple assumed that it wouldn't stop there when it refused to unlock the two phones. The phone lies in the thousands of man-hours needed to open not just this phone but other phones as demanded by law application, according to the article A Tale of Two Phones, Espino 2017. The mandate that the phone providers record all inbound and outbound numbers on cellular devices and the demand of geolocating are two further instances of how the All Rights Act of 1789 has been controlled and applied in the 20th and 21st century. Intellectual properties law. Intellectual property law have been utilized to safeguard those creative people who have transitioned from paper to the internet in line with the All Rights Act of 1789. Copyright, trademark, and patent protections are all included in these kinds of legislation. Why does this matter? So, these regulations guide against the unpaid exploitation of other people intellectual property. These regulations, for instance, prohibit the use or distribution of musicians' original composition without consent and remuneration. This also provides protection for software developers. For instance, they are also shielded from having their possessions used without their consent or compensation if they develop new software or applications. The order of the paper, the idea exclusion in intellectual law, which states that these rules delineate and preserve the open world of ideas for limitless individual choice and development, highlights the significance of these regulations for creative people. Martiman 2020. Cybersecurity laws. This regulation must be upheld in light of the numerous technological development in the globe and continually updated to reflect new developments. To ensure that individuals and their personal information are secure on the internet, there has to be an organization to police these regulations. According to Taylor's essay, To Steal or Not to Steal, Computer Fraud and Abuse Act of 1986 was criminal legislation that was created as an ordinary law to address crimes involving computers. Taylor 2012. The CFAA was initially drafted in 1986 with the intention of serving as an amendment to deal with hacking. Hundreds of instances have used the CFAA, but the most pertinent one is included A disgruntled employee who stole the company's customer database password and private data belonging to the client was included in this breach, which the employee took use of for his own benefit. The offender was located by the CFA, who also managed to get him arrested and sentenced to 4 years in jail for his transgressions. For the protection and safety of everyone who depends on the internet and technology, this is a perfect illustration of why cybersecurity laws are crucial and why having authorities for enforcement is essential. In the first to use INC Colley. Colley posting of decoding codes on his website was a blatant violation of copyright laws in the Universal Studio INC vs. Colley case. When movies are copied into DVDs, the films are created the discs to prevent unauthorized playing or duplication, and they are then sold for a profit, with the movies not included. Colley claimed he was entitled to do so due to his First Amendment right to free speech after putting the secure codes on his website, allowing any DVD to be duplicated and sold. Colley was sued by 8 separate motion picture corporations, all of which prevailed in the lawsuit because they possessed the sole rights to digital movies that he had posted encryption codes for. Conclusion: the nature of our daily lives has changed. So this is the conclusion, and this is the references we have provided. Thank you very much. So we also have, as you can see, we also have